To essentially do a part two of a talk that I gave on the Senate floor about 2 weeks ago. The first part of my talk was my analysis of the Dobbs decision of the Supreme Court, expressing my deep disillusionment with the court's decision to cast aside a century of precedent under the 14th Amendment Due Process Clause, and in particular, casting aside 50 years of using the 14th Amendment to protect women's rights to make reproductive decisions with regard to contraception and abortion. I analyzed the court's opinion and precedents at that time, but I sort of left it hanging what needs to be done. Because while we can critique the court decision, and I do view it as completely ahistorical and not understanding the purpose of the 14th Amendment, nevertheless, the court's majority ruling was the protection of reproductive freedom was now no longer a matter for constitutional protection, but was instead for legislatures. The majority seemed to assume that that would be state legislatures, but at least one of the concurring opinions acknowledged legislatures could include Congress. And I take the floor today in the second part of this talk to discuss a bill that I have today introduced with three other Senate colleagues, Senator Sinema, Senator Collins, Senator Murkowski, the Reproductive Freedom for All Act, taking the Supreme Court up on the challenge that what we need to do to protect reproductive freedom is to legislate to do so. Let me describe the origin of the bill. Beginning in February, the Senate has had two votes on a bill that I have co-sponsored, the Women's Health Protection Act, which was designed, written before the Dobbs case, but designed to protect reproductive freedom by disabling state legislatures from putting schemes and obstacles in the way of women making reproductive decisions. The first time we had a vote on that bill, I voted yes. It was in February. It received 49 votes. We were scheduled to have a second vote on the Women's Health Protection Act in May, and it occurred to me that we would likely have the same result. We would get 49 votes. And I had a strong feeling before that vote that if that was the case, we would be leaving votes on the table. By that, I understood from talking to my colleagues that there were more than 49 members of this chamber who wanted to codify Roe and related cases and protect women's rights to access contraception and abortion services, but that it wouldn't be ideal to send a message that less than a majority of the Senate was committed to reproductive freedom. And so I began efforts in May to find additional votes beyond the 49 that I knew would vote yes on the WHPA. And I began discussions with colleagues, including Republican colleagues, to look for a way to codify Roe that, yes, might be different in wording from the Women's Health Protection Act, but would accomplish the same goal of providing a federal guarantee that would operate in every zip code in this country to protect women's rights to make decisions about contraception and abortion. And today we have introduced that bill, the Reproductive Freedom for All Act. The name of it is a tribute to a ballot initiative that is currently under debate in Michigan and scheduled for a vote to be added to the Michigan Constitution in November, the Reproductive Freedom for All Initiative. And the bill that we have put together fairly closely tracks, not identically, but fairly closely tracks the language of the ballot referendum in Michigan. What does the bill do? We worked on the bill between the leak of the Dobbs opinion and when Dobbs was decided by the Supreme Court right before our July 4th recess. And we worked to make the bill as strong as we could, but then we set it aside because we knew the Dobbs decision might change from the leaked opinion, and we wanted to see what was actually in the opinion before we finalized the bill. And it is good that we waited because there were some aspects of the Dobbs opinion that were a bit different. They took some sandpaper to some controversial parts of the bill. They extended of the case, and they extended other arguments in the case that needed a response. And so what we have done since Dobbs is analyze the opinion, but also more importantly, look at life in the United States since that decision was rendered. I could give many examples of, even in the month since that decision has been rendered, of the tragedy of what I believe is now post-Dobbs America. In particular, when a 10-year-old child has to be smuggled across state lines to receive care following her rape, that is gruesome. That is not what this country should expect, nor indeed what we should tolerate. And yet that's not an accidental byproduct of the Dobbs decision. That was a completely foreseeable and even foreseen consequence of the Dobbs decision, that turning it over to 50 states would lead to a patchwork of horrible examples, one after the next. I've spoken about another example in Virginia. An individual who was living in Kentucky got a breast cancer diagnosis on the day the Dobbs opinion was leaked, went to her doctor and found out that her contraception could potentially cause accelerated growth of cancer cells, and so she needed to come off contraception to get cancer treatment. She has 2 young children. She's worrying about her own cancer. She's trying to keep herself healthy for herself, but also for her young children. If she were to come off contraception, there would be the chance of an unwanted pregnancy. The cancer treatments also would significantly degrade the possibility for a healthy pregnancy. But she was now living in a state that post-Dobbs would not allow her to have an abortion. She wrote a piece about this in NBC News, and she was fortunate enough to be able to move and get a new job in Virginia where she'd be able to make these choices. But these are the kinds of choices post-Dobbs that people are having to make every day. Do we smuggle a youngster across state lines, or does someone move from one state to the next? Every person in this country, no matter what zip code they live in, should have a basic federal guarantee about contraception and the availability of abortion services. And so what the Reproductive Freedom for All Act would do would be, Madam President, essentially we tried to put ourselves in a time machine after Dobbs and travel back to the day before the Dobbs decision. It was a very narrow focus. You can look at this in other ways. Some folks didn't like what the law was the day before the Dobbs decision, but in order to find some bipartisanship, because truly the American public on a bipartisan basis wants to preserve reproductive rights, we looked at, could we come up with a federal statutory guarantee that would match the state of constitutional law that existed the day before the Dobbs decision, and protect the rights of all to contraception access, and also protect the rights of all to abortion access as it existed before Dobbs. And simply put, that is this, that prior to fetal viability, no state can pass any statute regulating abortion that imposes an undue burden on a woman seeking to exercise that right. And post-viability, while a state can more significantly regulate abortion, no state can deprive any woman of the right to receive an abortion should she and her health providers determine that it's necessary to protect her life or health. And so that is the bill that I've introduced today with Senators Collins, Murkowski, and Sinema, and I thank them for working to try to show, because now we have shown that there's not a minority of the United States Senate, but there's actually a majority that wants to codify Roe and related cases, that we might have some differences of opinion about the right language to use to do that, but there's a difference between a Senate where that is only a minority sentiment and a Senate where, like in the rest of the American public, that is a majority sentiment. The last thing I'll say is this. I'm very well aware, as are my co-sponsors in introducing that bill, that we do not have the votes today, should it be put up, to get 60 votes in the Senate for it. We don't. We don't. And yet I am given some inspiration by the fact that we recently passed a gun safety bill where 2 months before there were not 60 votes either. In fact, For the 10 years I've been in the Senate, we've been trying to pass legislation in this chamber to deal with the scourge of gun violence, and again fallen short of 60 votes, even to proceed to legislation. But in the aftermath of tragedies in Buffalo and Texas, a decision was made by the members of this deliberative body that inaction was no longer an option, and resolute action to protect people's rights and safety was a mandate. I believe the Dobbs decision and what we've seen since is a catastrophe that, as it plays out over time in state after state, will also change the dynamic in the Article I branch and demonstrate the need for a national protection for reproductive rights rather than a 50-state free-for-all and a race to the bottom. And so it is in that spirit that my colleagues and I have introduced this bipartisan bill today, demonstrating that there's now bipartisan support and majority support in the United States Senate to protect reproductive freedom for all. With that, Madam President, I yield the floor.